Hello, how are you? My name is Nouman Jahangir. By profession, I am a lawyer and I practice law in Lahore, Pakistan. I am a lawyer of Lahore High Court. My number and my WhatsApp number is +92 324 41 39397. In case of any emergency, legal emergency or legal help, you people can contact me. Uh, I will answer you and redress your complaint. So today I am gonna read the section 4 and 5 of Code of Criminal Procedure. Earlier in my previous video, I had read the section 1 to 3 of Code of Criminal Procedure 1898. So today I am gonna read the section 4 and 5 of Code of Criminal Procedure 1898. So let's start. Section 4 of Code of Criminal Procedure of Pakistan 1898 deals with definitions, words referring to acts and words to have same meaning as in Pakistan Penal Code. Pakistan Penal Code is different from the Code of Criminal Procedure Code. Pakistan Penal Code, the purpose of Pakistan Penal Code is to provide the uh, a book, basically a book relating to the penal laws, and in order to provide the code for the criminal offenses. It describes the what is called an offense and what wrongs are fall in the penal offenses of Pakistani law. So section 4 defines that words to have same meaning as in Pakistan Penal Code. It means that words which are in Pakistan Penal Code has the same meaning also in this Code of Criminal Procedure. Code of the difference between Pakistan Penal Code and Code of Criminal Procedure is that Pakistan Penal Code deals with the offences of Pakistan, whereas Code of Criminal Procedure of Pakistan deals with the procedure of uh, running the uh, trial and the procedure of criminal uh, criminal trial in the and criminal procedures in the courts of Pakistan. Whereas Pakistan Penal Code defines the uh, and gives the definitions of the wrongs and the information of the offences of which are committed in Pakistan. And Section 5 of Code of Criminal Procedure deals with trials of offences under Penal Code, means offences of trials which are as I was stated earlier and telling you that about Penal Code. It basically Section 5 basically deals with and defines the trial of offences under Penal Code. Means all the trials which happens in the Penal Code, uh, it is defined in this code and in this section that how these trials should be done, trial of offences against other laws, and it also is section all it this section 5 the Code of Criminal Procedure also describes the procedure of trial of offences against other laws, like how trial of other offences should be dealt. mm, uh, it should be dealt. This code of criminal procedure also describes the procedure of that uh, trials too, which doesn't come in the ambit of Pakistan Penal Code. So now I am gonna read the details definitions of both the sections. So let's start definitions. Section 4 of Code of Criminal Procedure 1898. Section 4's definition states that in this code the following words and expressions have the following meanings unless a different intention appears from the subject or content. Means the words and expressions which I am gonna uh, read now. Uh, this will have the following meanings unless a different tension appears from the subject or content, unless there would be some other intention and definition of the subject or content would be taken into account. So, first word is and first expression in which is described here, section 4, subsection 1, and its class A. It is advocate general. Advocate general includes also a government advocate or where there is no advocate general or advocate or government advocate. Such officers as the provincial government may from time to time appoint in this behalf. So this basically this subsection A of subsection this class A of subsection 1 of section 4 of Code of Criminal Procedure describe the meaning of the Advocate General, and describing that Advocate General includes also the government advocate. Government advocate can be anyone and which any government appoints, and or where there is no advocate general, and where there is no advocate general mean there is no advocate general or government advocate. Such officers as the provincial government may time to time appoint in this law, and where there would be no advocate general or government advocate, such officer and provincial government appoint any person in this behalf that would become in the definition of advocate general. And now I will move to class B of this subsection 1 of section 4, and this is in and the expression which is given here is bail of an offense, non-bailable offenses. Basically these are two expressions uh, which are one of which is bailable offense and whereas the other one is non-bailable offense. Bailable offense means an offense shown as bailable in the second schedule or which is made bailable by any other law for the time being in force, and non-bailable offense means any other offense. So this is this class B of subsection 1 of section 4. This is basically describing the definitions of bailable offense and non-bailable offense. So it is stating that bailable offense means an offense shown as bailable offense in the second schedule. Second schedule is given in the code of at the very end of the Code of Criminal Procedure, and the in the second schedule there is a detail available that which offences should be comes in the definition of bailable offences or non-bailable offences, and it also describes that in which offences and in which sections there would be uh, a warrant would be required, or there wouldn't be the need of any warrant, and it also tells that which section is the trial and would be conducted before which class of magistrate and or officers. And so basically this is the section, schedule second schedule, which tells of code of criminal procedure 1898, which describes all the information regarding these types of things. So here what this class B is telling is that available fence uh, i- meaning is that an offense shown as payable in section 2 means any offense which is available and shown in the second schedule is available offense. This is the basic purpose of describing this is the basic purpose of this definition here. So and all those and which is available by any other law for the time being enforced, and all the other laws um, in which offences are available. This will also be counted as the bailable offence in code of criminal procedure, and all the other offences which are non-bailable offences, this will also be considered as the non-bailable offences in code of criminal procedure. So the next section is the subset class is class C is relating to charge. Charge includes any head of charge when the charge contains more heads than one. Charge means which charges are framed after someone is arrested, and charge means any head of charge when the charge contains more head. Once this can have several meanings, but here what I am saying is that head of charge means that um, here I am thinking that here the meaning of charge is relating to the offense. So it is maybe it is certainly would be relating to the offense, and when there are more charges, more when the charge contains more heads than one, then it would be called a charge. And subsection class D is omitted. Class F is relating to the cognizable offenses. So it has become video is becoming very long, and I just have to record the video of 15 minutes. So let's do the um, last class. This is no last class, but in the video, I am gonna read this my last class, and it is the class uh, F. Cognizable offenses. Cognizable offense and cognizable case. Cognizable offense means any offense for and cognizable case means a case in which a police officer may, in accordance with the second schedule or under any law for the time being, enforce arrest without warrant. So basically, this is This definition is describing the meaning of cognizable offense and cognizable case. And cognizable, it is telling that cognizable offense is an offense and cognizable case is a case in which police officer for the time in accordance with the second schedule of this same code or under any other law for the time enforced may arrest without warrant. All the cases and all the offences in which police can arrest without warrant uh, are called the cognizable offences and cognizable cases. And this is a very relevant and important um, clause too, because uh, police can only lodge the FIR in cognizable offences and under section 154 of this same code of criminal procedure. If a case and offence is cognizable, then police cannot lodge an FIR. And in all those cases where defense is not cognizable and case is not cognizable, then a private complaint is filed under section 200 before the magistrate, relevant magistrate of the area. So today I'm gonna close my video, and next time it has become over 17 minutes. I was trying to make it um, between 15 minutes. So next time the remaining section and clauses which have left behind today, I am gonna complete and cover that in my next video. For that time, thank you. Allah Hafiz. Mm, thank you for your precious time.